Mr. Carpenter, please call the roll.
Senators Aguilar, Baumgardner, Cook, Coram, Court, Crowder, Donovan, Finberg, Fields, Garcia, Gardner, Guzman, Hill, Holbert, John, Jones, Kagan, Kafalis, Kerr, Lambert, Lumberg, Marble, Martinez-Jimenez, Merrifield, Moreno, Neville, Priola, Scott, Smallwood, Sonnenberg, Tate, Todd, Williams, Zinzinger. Mr. President.
Here. With 34 present, 0 absent, 1 excused, we have a quorum. Senator Fields, would you please kindly come and lead us in the pledge?
Good morning, Mr. President, colleagues, and chamber guests. Please join me for the pledge to the United States of America.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Approval of the journal. Senator Finberg.
Thank you, Mr. President. I move that the reading of the journal of January 24th, 2018 be dispensed with and that the journal be approved as corrected by the Secretary.
Were you reading that off your phone? Were you reading that off your phone? I stole this off the podium fair and square, Senator. You have heard the motion. Is there any objection? Seeing none, the motion is adopted. Majority Leader Holbert.
Thank you, Mr. President. I move the Senate proceed out of order for a moment of personal privilege.
Motion before the body is for the Senate to proceed out of order for a moment of personal privilege. All those in favor say aye.
Aye.
All opposed, no. The ayes have it, and the Senate will proceed out of order for a moment of personal privilege. Senator Martinez-Humenic.
Thank you, Mr. President. I ask for a moment of personal privilege.
Granted.
Thank you. Today, colleagues, I just wanted to let you know, for those of you who have not heard, that last night, the Adams County Sheriff's Department and Communities lost a devoted deputy who had served with the department since 2013. Officer Deputy Heath Gum, 32 years old, lost his life while pursuing a suspect believed to be involved in an assault near the southern border of Thornton and unincorporated Adams County. He was engaged in doing his job, what our first responders do every single day, putting their lives on the line. While one suspect was apprehended last night with the help of multiple jurisdictions from across the metro area, they are still seeking 2 other suspects in this matter. So if you have any information that would be helpful in finding the suspects that were involved in this tragedy last night, please do call 720-322-1313 and share that information. As I drove by there this morning, multiple jurisdictions were still in the area, keeping the neighborhoods cordoned off with police tape, and 12 schools have been shuttered today because they are continuing to look for the suspects. A fund for Deputy Gum's wife and family has been set up. You can go to the website for the Colorado Police Officers Foundation and make a donation, or if you'd prefer to mail a check, you can send it and make it out to the Colorado Police Officers Foundation, 8400 Alcott Street, Westminster, Colorado, 80031, and in the subject line, please state it is for Deputy Gum's fund, and all of the money that is collected, 100% of it, either from the website or from checks that are mailed in, will go to his wife and family. Our hearts are heavy this morning as we remember the dedication and service of Adams County Deputy Heath Gum, who died protecting the lives of others in a job that he loved to do. I would like to request that we observe a moment of silence and have the chimes rung as a tribute and in memory of Deputy Gum.
If Senators Moreno or Priola have any comments, we could take those now. Senator Moreno.
Thank you, Mr. President and colleagues. I really thank my friend and colleague, the good senator from Thornton, to have a few moments this morning to remember Deputy Gum. He was with the Adams County Sheriff's Office since 2013. First Deputy Parrish and now Deputy Gum. It's far too much tragedy to start the new year so early. And I think it's incumbent on all of us to remember and recognize the important role that law enforcement plays in our lives, that they protect our communities and they put themselves in harm's way every single day to make sure that we're all safe. So I appreciate us taking a little bit of time this morning to remember Deputy Gum.
And I actually want to thank the good senator from Thornton for bringing this, and this really hits home. This happened just down the street from where my great-grandparents built a house many years ago, and our family had our greenhouse. So a lot of these tragedies are in other countries or other states, but this is very close to home, and my thoughts and prayers go out to the Adams County Sheriff's Department.
Senator Martinez-Humenic.
And again, I just want to remind everybody that a wife lost her husband, a family lost their father, the Adams County Sheriff's Department lost a member of their family, and all of our law enforcement across Colorado and the nation who serve lost a valuable member of their family. So again, I would like to request that we observe a moment of silence and have the chimes rung in tribute and in memory of Deputy Heath Gum.
In honor and in memory of Deputy Heath Gum, the chimes will ring out and we will observe a moment of silence.
Thank you, colleagues.
Thank you, Senators. Committee reports.
January 25, 2018, Committee on Appropriations. After consideration of the mayor's committee recommends the following. House Bill 1116 be referred to committee of the whole with a favorable recommendation. January 24, 2018, Committee on Judiciary. After consideration of the mayor's committee recommends the following. Senate Bill 60 be amended as follows as submitted. Be referred to committee of the whole with a favorable recommendation. Recommendation be placed on the consent calendar. January 24, 2018, Committee on Health and Human Services. After consideration of the mayor's committee recommends the following. Senate Bill 54 be amended as follows as submitted. Be referred to committee of the whole with a favorable recommendation. January 24, 2018, Committee on State Veterans and Military Affairs. After consideration of the mayor's committee recommends the following. Senate Bill 49 be postponed indefinitely. January 24, 2018, Committee on State Veterans and Military Affairs. After consideration of the mayor's committee recommends the following. Senate Bill 53 be postponed indefinitely. January 24, 2018, Committee on Business, Labor, and Technology. After consideration of the mayor's committee recommends the following. Senate Bill 81 be postponed indefinitely.
Senate Services.
Correctly printed, Senate Bill 105. Correctly re-engrossed, Senate Bill 19, 20, and 41.
General Order, second reading of bills, consent calendar. Senator Tate.
Thank you, Mr. President. I move that the Senate resolve itself in the Committee of the Whole for the consideration of general orders, second reading of bills, consent calendar.
Motion before the body is to resolve itself in the Committee of the Whole for consideration of the general order, second reading of bills, consent calendar. All those in favor say aye. All opposed, no. The ayes have it. And the Senate will resolve itself in the Committee of the Whole for consideration of the general order, second reading of bills, consent calendar, and Senator Tate will take the chair.
The committee will come to order. Mr. Carpenter, will you please read all the titles to the bills on the consent calendar?
Senate Bill 25 by Senator Priola and Representative Coleman concerning modernization of election procedures for the urban drainage and flood control district to conform with current requirements of state law. Senate Bill 44 by Senator Crowder and Representative Landgraf concerning the ability of private employers to give preference to veterans when making certain employment decisions.
Majority Leader Holbert.
Thank you, Mr. Chair. I move both of the bills on the general order, second reading of bills, consent calendar consisting of Senate Bill 25 and the committee report from State Veterans and Military Affairs, and Senate Bill 44.
Is there any discussion on any of the bills on the general order, second reading of bills, consent calendar? Oh. Is there any discussion on any of the committee report, on any of the one bill with the committee report on the consent calendar? Seeing none, the motion from the body is the adoption of the committee reports. All those in favor say aye. Aye. All those opposed, no. And the committee report has been adopted. Is there any discussion on any of the bills on the consent calendar? Seeing none, the motion before the body is the adoption of the bills on the general order, second reading of bills, consent calendar. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and the bills are adopted. Majority Leader Horbert.
Thank you, Mr. Chair. I move the committee rise and report.
The motion for the body is to rise and report. All those in favor say aye. All those opposed, no. The ayes have it, and the committee will rise and report.
The Senate will come to order. Senator Tate.
Thank you again, Mr. President. The committee has met and had a number of bills under consideration. Mr. Carpenter, will you please read the report?
Mr. President, your committee of the whole begs the lead reports had on consideration the following attached bills being the second reading thereof and makes the following recommendations thereon. Senate Bill 25 is amended. Senate Bill 44 passed on second read, order engrossed and placed on the calendar for their reading and final passage.
Senator Tate.
Thank you, Mr. President. I move for the adoption of the report.
The motion is for the adoption of the report to the Committee of the Whole. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, the Committee of the Whole report is adopted. General order, second reading of bills. Senator Tate.
Thank you again, Mr. President. I move that the Senate resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills.
Motion before the body is the adoption, the motion before the body is to resolve itself into the Committee of the Whole for consideration of the general orders, second reading of bills calendar. All those in favor say aye. All opposed, no. Motion is adopted, and the Senate will resolve itself in the Committee of the Whole for consideration of the general orders, second reading of bills, and Senator Tate will take the chair.
Good morning again. The committee will come to order, and this time the court will is relaxed. Mr. Carpenter, will you please read the title to Senate Bill 15?
Senate Bill 15 by Senators Gardner and Hill and Representatives Williams D. and Liston concerning the Protecting Homeowners and Deployed Military Personnel Act.
Senator Gardner.
Thank you, Mr. Chair. I move Senate Bill 15. There is no committee report.
Senator Gardner.
Thank you. Members, this is the Homeowners and Deployed Military Personnel Protection Act. During the committee hearing in Judiciary, there were some technical issues raised by the District Attorney's Council, and I agreed immediately because they were issues that only lawyers can love. To offer amendments to resolve those matters. So at this time, I would offer L001 and move L001.
Thank you, Senator, for calling our attention to the amendment phase. There are amendments on the desk. The first amendment we've received is Amendment L006. Yes, and Mr. Carpenter, will you please read Amendment L006?
Amendment L006 to Senate Bill 15 by Senator Kagan, amend printed bill page 2, strike lines 4 through 6 and substitute section 2 in Colorado Revised Statutes, add Article 40.1 to Title 13 as follows. Article 40.1, removal of unauthorized persons. 1340.1101, removal of unauthorized persons. Definition, page 2, strike lines 14 through 16 and substitute residential premises by filing with the county court a request for a temporary mandatory injunction restoring possession of the residential property of the owner. The request should be substantially in the following form.
Senator Kagan.
I move Amendment L006.
Thank you, Senator. To the bill. To the amendment.
Thank you. I would like to say, members, how very much I appreciate Senator Gardner bringing this bill on a very important subject that is very vexing to the people of Colorado. And it is an excellent bill, and if amended by L006, I urge an aye vote on the bill as amended. I'd like to tell you why I think this is such a good bill and why I so strongly urge an aye vote on the bill, as I hope it will be amended by L006. These situations where you have a home invasion and a bunch of squatters just take over your house and say, "We're here," is a terrible situation for a homeowner. And the virtue of Senate Bill 15, on which I urge an aye vote if amended by L006, the virtue of Senate Bill 15 is that it does, in those squatter home invasion situations, say, look, you homeowner, you don't need a lawyer, just make a declaration under the penalty of perjury, laying out the situation. We'll tell you exactly how to lay it out, because it's laid
Senator
out.
Senator Kagan, for a brief moment. If everyone in the Senate here could take their conversations to a quieter level or outside if necessary, appreciate it, so the senator can be heard. Senator Kagan, if you could proceed.
Thank you. It says you don't need a lawyer because we'll tell you exactly the substantially the kind of form that you need to fill out and what you need to declare. These are good aspects of the bill, and that's why I'm urging an aye vote on the bill if it is amended by L006. It also provides for a very quick eviction process. You don't have to wait a week or 2 weeks. You just fill in the form, take that to the sheriff or the law enforcement officer, and the law enforcement officer has no discretion now. The law enforcement officer shall go and evict those problem squatters who are parasitically taking your property rights from you as you speak to the law enforcement officers. So it gets it done quickly, and it gets it done effectively, and it gets it done without the need for counsel. All of these aspects of the bill are good. Another good aspect of the bill, which, if amended by L006, will remain, is that the declarant has to make his declaration or her declaration under the penalty of perjury, which is a deterrent in the home invasion squatter situation against making a false declaration. And that is good. And that also will be kept in Senate Bill 15 if it is amended by L006. The police do not face ambiguity in Senate Bill 15, and they do not face ambiguity in Senate Bill 15 as amended by L006. But there is one serious, well, there's more than one serious flaw, but a serious flaw in the bill, if not amended, is as follows. Paragraph 4A of the bill says that the peace officer shall remove the person if the declaration is made out. Not may, not must, shall. That is a legal obligation, unconditional obligation. The peace officer shall remove. Later in the bill, paragraph 6 of the bill, as it is unamended, says the peace officer must consider evidence that the person is a legal occupant. So before the peace officer shall evict, they must consider evidence. If, for example, the person produces a lease, well, the peace officer must consider that. But having considered it, presumably with a stroke of the chin, he then shall evict, regardless of what the evidence is. And this highlights a real problem with the bill. What the bill seeks to do, and I applaud Senator Gardner for doing this, because Senator Gardner really understands that before these actions take place, there should be some opportunity for the person who is going to be evicted to say, well, look, actually, I have a perfect legal right to be here. And so he puts in the bill that the peace officer must consider that. But then elsewhere in the bill, he says that the peace officer shall evict. And this is because the bill seeks to provide a balanced judgment as to whether the person needs to be evicted, but seeks to provide certainty as to whether the person is to be evicted. So we can get over that situation with Amendment L006. And there is another flaw in the bill. Of course, when there is an obvious home invasion squatter situation, everything will be pretty clear. But this bill would also provide for immediate eviction in other situations where it would be far less clear. Suppose in the cash economy of low-income people, a guy has just scraped together enough money to get a very low rent apartment, has put together $200-300, goes to somebody who he was told has an apartment to rent, gives them the $200 or $300, and they have a lease agreement, oral perhaps, says, yeah, you give me the $200 or $300, you can stay there for the month, that'll cover your deposit and your first month's rent, welcome to my spot, here you are, you can sleep on the futon or sleep on the basement, or you can do whatever it is. And the guy moves in. He's moved out of homelessness. He's got enough money for a deposit and the first month's rent. Then, if the landlord or property owner is a crook, just like the parasite squatters are crooks, if that landowner is a crook, he can go 1 day later, having taken this deposit, having taken this first month's rent, swear out a declaration under penalty of perjury, and without question, that guy who just paid his $200 or $300 for his first month's rent will be thrown out. No court hearing, no opportunity for consideration of what the situation is. He will be thrown out. The law is unambiguous here. Another situation. A person signs a lease and moves into a place which has they've been victimized by a criminal. The person is selling them a fake lease. They move in, the property owner comes home, they say, you are in bad faith occupying my apartment, get out. And they say, no, I signed a lease with the guy who told me he owned it. And they say, no, I didn't know about it, you're out of here. And not only that, you're subject to criminal penalties because you altered the property, and no opportunity for any discussion of what is appropriate behavior there. Amendment L006 addresses all these situations, and it does so preserving the speed at which these events must take place. Amendment L06 says you come home, you find your property occupied by an unauthorized person, you make a declaration under penalty of perjury, you take that declaration to the county court, you request a temporary mandatory injunction restoring possession of the residential property to the owner, i.e. an eviction. It's a court order, you request it. The court, because it's an emergency order that you're requesting, the court holds the hearing as soon as practicable. In most areas, they have a 24-hour-a-day on-duty call judge. It might be in some courts the next morning, but it will almost always be within hours. The court hears the representations. The court decides if it's a simple homeowner situation, of course, homeowner invasion, the nightmare squatter scenario, the court will immediately, of course, sign it. But if it's a complex situation where the landlord appears to be a bit, maybe the one at fault, or maybe the tenant is the one trying to pull one over on the landlord, the court will quickly suss that out. And then the order issues. That, under the amended version of the bill, is then given to a police officer who must, within 24 hours, no discretion, must, because this has been heard through a court, must evict. Now, is it as quick as going straight to the sheriff? No. It takes maybe 4 or 5 hours longer. But what it does do is it enables a hearing on the temporary emergency injunction to take place so that victims cannot be re-victimized by unscrupulous landlords, which is especially a problem for low-income tenants who pay in cash for their housing, which is sadly what many people in Colorado are reduced to. So it preserves the rule of law, it preserves the quick process, it preserves the lack of a need for a lawyer, because we say in substantial form how you apply to the court for the temporary injunction. It is a vast improvement on the bill. I feel fairly confident that Senator Gardner will agree with me and urge an aye vote, as I do, to Amendment L006.
Thank you, Senator. Senator Gardner, L006.
Thank you, Mr. Chair. Well, just to be clear, I oppose this amendment and urge a no vote. I can understand why the senator from Arapahoe County might be looking for an exit door on this vote, given the public sentiment around this problem. And in fact, the senator from Arapahoe County's explanation of his amendment gives you the perfect reason why you should vote no on his amendment. As written, the bill provides an extremely straightforward and expeditious process on the spot for law enforcement to be able to remove squatters from the property. And it does require, once law enforcement understands that, in fact, these are squatters, that they assist the property owner in having them removed. What Amendment L006 would do is force that homeowner who lives, say, in eastern El Paso County or southern Pueblo County to suddenly have to go to the courthouse and find a judge, try to get a hearing with that judge. And I don't know, maybe in Arapahoe County or Denver County, maybe you can get a hearing if you're an ordinary citizen. You can just find a judge and get them to come right in and sit right down on the bench. But I have to tell you, even as a member of the bar of some years in El Paso County, that's probably a 3-day deal. And in the meantime, the squatters, who have now been given mandatory notice by the senator's amendment, will have all the time to trash your property, waiting for their court hearing. But I do understand why the senator from Arapahoe County might be looking for an exit door, because the public has been demanding that we do something about this. And I am mindful that this strikes the balance pretty strongly in favor of homeowners and people who own rental properties in this state. That's the intent, that's the choice. I ask for a no vote on L006.
Thank you, Senator. Senator Kagan, L006.
Thank you, Mr. Chair, and thank you, Senator Gardner. I would respectfully, Mr. Chairman, Mr. Chairman of the Judiciary Committee, take exception to one of the things that you said. Once the police officer establishes that it really is a home invasion, then the police officer evicts the tenants. And that is true, because if it's a home invasion, that's exactly true. But if the police officer is presented with a declaration filled out according to the law and comes and finds that it is not a home invasion, it is just a tenant that the landlord wants to see evicted, and he's made the necessary declaration, that police officer has no discretion at all. He can't decide, oh, this is not a home invasion. This is just a landlord with a tenant who claims, and under penalty of perjury has claimed, that it's subject to, that he's unauthorized and he came here without permission. I don't know whether he did or not. Doesn't look like that to me, but I have no discretion in this matter. So I'm going to treat it as if it's a home invasion in any case in which a declaration is brought to me. I am not allowed to judge the matter. Nobody else has judged the matter. In fact, Senator Gardner and the legislature are the only ones that have judged the matter in every situation where a declaration is made. Once the declaration is made and given to a police officer, if this law passes unamended, then in any situation, any tenant must be immediately evicted. No hearing, no nothing. So it does not depend on whether the police officer, in his or her judgment, thinks this is a home invasion. This can happen in downtown Denver. Landlord fills out their declaration, gives it to a police officer. That police officer comes, finds people sitting at home, apparently well settled. They say, look, we have a lease with the guy. He says, I've got no choice in the matter. The legislature has spoken. There is no right to a hearing. You have to go within 24 hours.
Thank you, Senator Kagan. Senator Gardner.
Thank you, Mr. Chair. Well, I simply would contend to you that the senator from Arapahoe County's rather lengthy dissertation, which is the sort of dissertation that occurs at the courthouse, is the best argument for why this amendment doesn't provide for an expeditious process for property owners. Quite the contrary. It will just lead people to hunt up judges, try to get a court hearing, and all the time the property owner's home is being trashed. I ask for a no vote on L06.
Thank you, Senator. Any further discussion on Amendment L006? The motion for the body is the adoption of Amendment L006 to Senate Bill 15. All those in favor, please say aye. All those opposed, please say no. No. The noes have it, and the amendment is lost. There are other amendments on the desk? Mr. Carpenter, will you please read Amendment L001?
Amendment L001 is Senate Bill 15.
Senator Gardner.
Thank you, Mr. Chair. I move L001.
Thank you, Senator. To the amendment.
Thank you. Mr. Chair, as I said earlier, the District Attorney's Council had some requests for revisions to refine the bill and how it operates with regard to criminal penalties. L001 makes clear that this new crime of altering or damaging a home when one is a squatter doesn't preclude the prosecution of violations under any other law, primarily criminal mischief, so that prosecutors would have kind of full latitude as to what is the best crime or perhaps both crimes to be prosecuted. I ask for an aye vote.
Thank you, Senator. Any further discussion on Amendment L001? Seeing none, the motion of the body is the adoption of L001 to Senate Bill 15. All those in favor, please say aye. Aye. All those opposed, no. The ayes have it, and the amendment is adopted. There's another amendment on the desk. Mr. Carpenter, will you please read Amendment L002 to Senate Bill 15?
Amendment L002 to Senate Bill.
Senator Gardner.
Thank you, Mr. Chair. I move L002.
The amendment.
Thank you. So, members, I have to say the bill provides that if a squatter alters or damages your home, then it constitutes a crime under this bill, a Class 1 misdemeanor. Rather astoundingly, during the hearing, it was raised, the question was raised, or it was raised by stakeholders in the hallway. Well, it says alter. So what if they fixed your garbage disposal while you were gone, if they fixed it for you? What if the squatters were so kind as to fix your garbage disposal? What if they replaced your curtains? They would have committed a crime. You know, if you're looking for a reason to not protect property owners in Colorado, I suppose you can find one. But to address this concern about what a simple alteration would be, we're adding the word materially, and that has meaning in the law, and there are jury instructions about it. And so one will have to materially alter the property if they're a squatter in order to have committed that crime, and I ask for an aye vote.
Thank you, Senator. Any further discussion on L002? Senator Kagan.
I also urge an aye vote on L002.
Thank you, Senator. Any further discussion on Amendment L002? Seeing none, the motion from the body is the adoption of L002 to Senate Bill 15. All those in favor, please say aye. Aye. All those opposed, no. The ayes have it, and the amendment is adopted. There's another amendment on the desk. Mr. Carpenter, will you please read L003?
Amendment L003, Senate Bill 15 by
Senator
Senator.
Gardner.
Thank you, Mr. Chair. I move L003.
The amendment, please.
Thank you, Mr. Chair. Another concern that was raised, and this was, frankly, pretty interesting to me. I had wanted, and in asking for the bill to be drafted, that we, as sponsors of the bill, had wanted to limit the removal, the privilege of removal to only peace officers. That seemed to be a matter of some concern to the District Attorney's Council. Because it was, I'm good with removing those provisions, and so what that does is remove the restriction that only a peace officer can make the restriction. So I believe it would be possible with this removed to require to have a security person do it for you, and that might be a good option for those who have property invaded by squatters, because the problem is rampant throughout Colorado. I ask for an aye vote.
Thank you, Senator. Any further discussion on L003? Seeing none, the motion before the body is the adoption of L003 to Senate Bill 15. All those in favor, please say aye. All those opposed, no. The ayes have it, and the amendment is adopted. Senator Gardner.
Thank you, Mr. Chair. I renew my motion for the passage of Senate Bill 15 as amended.
Thank you, Senator. The motion for the body is the adoption of Senate Bill 15. Any further discussion? Senator Fields.
Thank you, Mr. Chairs. And members, I was a no vote on this bill in committee based on the concerns that was raised by the District Attorney Council. But with the amendments, I am now a yes vote and want to thank the bill sponsors for incorporating their suggestions in this Senate Bill 15. Thank you.
Thank you, Senator. Further discussion? Senator Kagan.
Thank you, Mr. Chairman. I also urge an aye vote on this bill because I think it's better than not having a bill. I think it's a flawed bill because we didn't incorporate Amendment L006, a seriously flawed bill. I'm hoping that if this bill passes out of the Senate today, that those flaws in the bill can be remediated in the House and then brought back here before the joint body. But this is a serious problem. We can't leave it unaddressed. And I think we have to move the bill through the process in the hope that we can get its serious flaws, its lack of a hearing in any situation where it seeks really to address the squatter situation. It also gives unparalleled power to an unscrupulous landlord who's just trying to cheat a tenant out of his legal rights. So if we can get that addressed in the House, that would be a good thing, but we can't leave this matter unaddressed. I urge an aye vote on this bill.
Thank you, Senator. Any further discussion? Senator Hill.
Thank you, Mr. Chair. Colleagues, I ask for support on this bill as well. The question before us is, in a very mobile society, where are we going to side when it comes to the law? And we know the House is a place of security, it's a place of safety, it's one of the biggest investments you can make. Passing this bill is not just about putting squatters on notice today, but it's letting them know going forward you cannot take advantage of homeowners in a society where we move a lot, where military folks get deployed, and gives people the confidence and the peace of mind that indeed your home is your castle. And so I ask for your support on this bill.
Thank you, Senator. Any further discussion on Senate Bill 15? Seeing none, the motion for the body is the adoption of Senate Bill 15 as amendment. All those in favor, please say aye. Aye. All those opposed, no. The ayes have it, and the bill is adopted. Mr. Carpenter, will you please read Senate Bill 14?
Senate Bill 14 by Senators Cook and Fields and Representatives Wist and Hare concerning requiring the Department of Corrections to disclose the location of inmates who are relocated to facilities outside of the state.
Senator Cook.
Thank you, Mr. Chair. We move Senate Bill 14 and the Judiciary Report.
To the report.
Thank you, Mr. Chair. The Judiciary Report amends the bill saying that the DA no longer has veto power, and it gives the veto power over the Executive Director of Department of Correction, and it gives the veto to an independent judge from the current judicial district.
Thank you, Senator. Any further discussion on on the committee report? Seeing none, the motion is to adopt the committee report. All those in favor, please say aye.
Aye.
All those opposed, no. The ayes have it, and the committee report's adopted. To the bill, Senator.
Thank you, Mr. Chair. I bring Senate Bill 14. You know, we live in an open and free society. We don't have secret prisons or secret jails in this country. We're not like some of the other countries in the world where government can come in and arrest somebody and take them to jail or prison and you never see them again. That's why jails and prisons are required to list in a log who they have in there, who got arrested. So that way we don't have political prisoners and we know where people are at. Well, Senate Bill 14 says that the Department of Corrections must notify victims of crime where the inmate is located. For 20 years, we heard testimony in committee that there was a gentleman here in Denver whose daughter was killed 20 years ago, and he still does not know where the offender is at. Let me tell you where a letter that the victims receive. We heard this from Tom Sullivan, and this is all he got when the Aurora Theater shooter was moved out of state. It says, this is the letter he received. The DOC moves offenders to different facilities for a variety of reasons. Each case is different. However, some of the typical reasons include overall statewide bed management, programming needs of the offender, choosing classification and security considerations. VSU, or Victim Services Unit, is informed of specific reasons of the offender moved. That's a travesty. That's not being transparent. We worked with DOC when we started this process. They came into us and they outright lied to us about this, about why they can't release where inmates are located out of state. They told us, hey, we belong to this compact. And because of the compact, we cannot disclose where the inmate has been moved to. If we disclose it, we'll be kicked out of the compact, and we need that as a management tool. That's not true. I have a copy of the compact. Nowhere does it say that. So they lied to us. They lied to legislators. They lied to the public. They've been doing it for 20 years. This compact has been in place in '64, and they've been lying for decades. What this bill does says DOC must release the location to the prosecuting attorney and to any registered victim that wants to know where they're at. There are 4 exceptions because DOC does have the absolute right and duty to make sure inmates are safe. And those 4 exceptions are the inmate is a witness and the executive director determines that disclosing a location would be harmful to the inmate. Basically, that's the snitch rule. So if an inmate in prison is a snitch and they have to move him out of state for his safety, then they don't have to release the location. If the prosecuting attorney requests that the location not be disclosed, and that's the same thing. If the prosecuting attorney has some information that might put the inmate safety in jeopardy because that inmate gave information to the prosecuting attorney. The registered victim is currently incarcerated. So if the inmate was assaulted in prison and there was a hit out on that inmate and they need to move him out of state, his location might not be revealed. And the other one is if the person is a former law enforcement officer and or a correctional officer. So those are the safeguards. And we understand from the Department of Corrections there's only about 3 currently out of the over 115 inmates that are in out-of-state prisons. That would apply to about 3. If the DA disagrees with the executive director, he can file a motion with the court, as can the victim, file a motion with the court to say, we don't agree with the executive director on not disclosing, and then it goes to the judge to determine whether or not that inmate's location should be disclosed.
Thank you, Senator. Senator Fields.
Thank you, Mr. Chair, and thank you, my good friend and colleague from Weld County, for partnering with me on this bill on behalf of crime victims. What I appreciate most about working with the senator is that he listened to the voices of victims, he respects the voices of the victims, and he understands the important role that victims play in seeking justice. This bill is very important to me and my constituents in Arapahoe County. I was concerned about this at the end of the session. I tried to run a bill to address this matter, but we just ran out of time. The Department of Corrections have been keeping victims in the dark far too long. If you know anything about victims' rights, it says that victims have a right to be treated with fairness, respect, and dignity. They also have a right to be informed and to participate in every critical judicial proceeding that's taking place as it relates to the person that committed this horrific crime. The Victims' Rights Act has been codified in our statute since 1992, and what the Department of Corrections has done is they have made up their own interpretation of the statute as it relates to victims' rights. So when we had the parents from the Aurora Theater shooting show up and ask, I just want to know after the trial, I want to know where the killer is. I want to know where the rapist is. They were told no. They went to the highest level that you can to seeking information about where is the killer, where is the rapist, and they were told, we cannot give you that information. And the only rationale they were given was because they were considered temporary. They were in this temporary transfer out of the state. And because they were out of the state, it was to be a secret. That's nonsense. That's nonsense. Those victims have a right to know. And when they testified in committee, they said the reason they wanted to know because it gives them a peace of mind. We heard a letter from Jessica Ridgway. She was raped and kidnapped and murdered. And the only thing she wants is to know where the offender is. And they told her, no, we can't share this information. But yet, that killer's parents gets to know where that offender is, but not the loved one. I think it's wrong for the Department of Corrections to have concealed and to keep this information secret from the folks who have been harmed by crime. This is outrageous, and what Senate Bill 14 will do will make it sure that another victim, when they request where their perpetrator, an offender is, they have a responsibility. It's already on the website. They are entitled to know where the offender, the killer, the rapist is. So this whole idea about this temporary status, we can't tell you. Most people in corrections are in a temporary status. If that was the case, no one would be able to know where their offenders are. So it's just outrageous, and it just doesn't make sense that we would do this. So in the end, it's like, who am I protecting? And who am I fighting for? So today, this bill is about fighting for Jessica Ridgway. This bill is about protecting and fighting for Tom Sullivan and his son, Alex, who was killed in the Aurora Theater shooting. Who am I protecting and who am I fighting for? I'm fighting for the A.J. Boykin, I think it is his last name, and his mother, Teresa Hoover, testified in committee. I'm fighting and protecting her rights to be able to find out where the killer is. That's all they want to know, is where they have been relocated. Now, what happened in this case, in the Aurora Theater shooting, we know where he is, because as soon as he was relocated or transferred out of state, the feds, he's in a federal prison, they announced it. And he's in Pennsylvania. So if the federal government can announce it, why can't the state of Colorado give a peace of mind to the victims to let them know where their killer is? This is the right thing to do, and I urge an aye vote on Senate Bill 14.
Thank you, Senator. Senator Crowder.
Thank you, Mr. Chair. I just have a couple questions. I'm not sure I understand exactly how the transport of prisoners to other states works, but let's say that Colorado, for whatever reason, transports a prisoner to Kansas. And then a little bit down the road, Kansas actually transports that prisoner to Pennsylvania. If that were to happen, is the state of Colorado still responsible to find out or keep track of where that prisoner is? And my second question pertains, this is just for state prisons. How does this affect the federal prison system? Do they adhere to that because the federal prison is in Colorado? And these are just a couple questions I had for the sponsors.
Thank you, Senator. Senator Cook.
Thank you, Mr. Chair. Regarding the second question, the federal government is part of the compact. So they've signed on with, I think it's like 32, 36 other states. So the federal government is part of the compact, and so we move inmates to federal prisons throughout the country. As the good senator from Aurora said, the Aurora Theater shooter is in a federal prison. As far as the first question, yes, they're still Colorado inmates, even though they're housed in another state. So if Kansas wants to move them to Pennsylvania or someplace else, then Kansas will notify Colorado, and Colorado will know, and then Colorado is responsible to let the victim know where they've been moved to.
Thank you, Senator. Any further discussion? Senator Kagan.
Thank you, Mr. Chairman. I want to thank the sponsors of this bill for bringing it forward and for shepherding it through the process. Very important to the victims that they know where their victimizers are located. It's something to do with peace of mind, and it's something that can only be fully appreciated and fully understood by someone who has been victimized in this way, I suspect. And so this is an important bill, and I really appreciate the sponsors bringing it forward. I did want to come forward, however, to give my understanding of the discussions previously with the Department of Corrections. I do not believe it's fair to say that they have acted in bad faith. I do not believe it's fair to say that the Department of Corrections, this is my interpretation of previous events, lied to anybody in this chamber. They did interpret their obligations for the protection and preservation of the safety of their officers and the safety of their inmates. They interpreted their obligations differently than the sponsors of this bill. They interpreted the obligations under the Interstate Compact differently than the sponsors of this bill. And because it was not absolutely clear what their obligations were, that is why it's so important that Senator Fields and Senator Cook have brought this clarifying legislation forward to make it absolutely clear where their obligations lie. But the thought that they were acting in bad faith previously, I think, is not one that is fair. And so I just want to go on record as saying I think the Department of Corrections has acted in good faith, but will be vastly benefited by this clarification. I urge an aye vote.
Thank you, Senator. Senator Fields, I think you were next.
Thank you, Mr. Chair, and thank you, Senator, for those remarks. I can tell you that the victims felt like it was unfair to them, because on their website it says that they are entitled to know where their killer or their rapist is being housed. That's the law. It's in the Constitution. So to give the impression that, you know, in good faith, I question that a little bit. Because at the end of the day, the Department of Corrections came to committee, and they're in support of this bill. Now, it took some effort. We worked really hard to come up with the language that you now see in this bill. So they're in support of this bill. But I can tell you, their concerns are our concerns as it relates to making sure that inmates are safe and to make sure that the prison guards are safe. And it addresses that. But to deny a victim the right to know, in my view, that is not something that's unclear. It's very clear in statute. And they should not have been told, no, that you don't have a right to know. In my view, that's just flat out wrong.
Thank you, Senator. Senator Cook.
Thank you, Mr. Chair. I don't know, bad faith, incompetence, I don't know what you want to call it. But here is the compact. It's 10 pages long. That's it. The compact's been around since 1963. Maybe government agencies ought to pull these things out of their desk and dust them off once in a while and reread them, because I read it in a few minutes, and again, nowhere in this compact does it say that the locations of inmates cannot be released. While we're having a sidebar here, a good senator came and asked me about whether victims can opt in or out. Basically, what happens when a victim, under the Victims' Rights Act, can opt in and ask the Department of Corrections to be notified. And if they register with the Department of Corrections, then they will be notified, and only at that time, if they're registered. And then I would like to close just really briefly with Christina Ridgway's letter to the committee. She was unable to make it. She's the grandmother of Jessica Ridgway. And this is what she wrote. The current process for notifying victims for the whereabouts of the perpetrator in many cases is very difficult for the families. Sometimes we don't want to know, but sometimes we do. In my case, it is a virtual box, or in my case, it is virtual boxes that sit in my living room. All of Jessica Ridgway's life mementos and memories of her are in one box, and I am okay with that box. I look at it and savor these memories a lot. The other box I trip over. It is a case after her murder. It is the court process, the investigation, and the face of her murderer. There are details in the box. Some of my family know, and some others don't want to know. I hate that box, and I need to have that box closed and moved to the top of my garage. I can't really say why it is important. It just is. Knowing where the perpetrator is helps my family, and that is not closure, because there really never is closure. Just helps to know and move on for future families, which I never wish to on anyone. Please consider the measure to change the wording of the law. Thank you, Christina Ridgway. I would renew the motion for a yes vote on Senate Bill 14.
Thank you, Senator. Any further discussion on Senate Bill 14? Seeing none, the motion before the body is the adoption of Senate Bill 14. All those in favor, please signify by saying aye.
Aye.
All those opposed, no. The ayes have it, and the bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee rise and report.
The motion for the body is to rise and report. All those in favor, please say aye. All those opposed, no. The ayes have it, and the committee will rise and report.
Senate will come back to order. Senator Tate.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Mr. Carpenter, will you please read the report?
Mr. President, the Committee of the Whole begs leave to report is had on consideration the following attached bills being the second reading thereof and makes the following recommendations thereon. Senate Bill 15 is amended. Senate Bill 14 is amended. Passed on second read order and engrossed and placed on the calendar for third reading and final passage.
Senator Tate.
Thank you, Mr. President. I move for the adoption of the report.
Motion before us is the adoption of the report to the Committee of the Whole. Are there any no votes? With 34 ayes, 0 noes, 0 absent, 1 excused, the Committee of the Whole report is adopted. Senate Bill 15 is amended. Senate Bill 14 is amended. Passed on second reading, ordered engrossed and placed on the calendar for third reading and final passage. Majority Leader Holbert.
Thank you, Mr. President. At this time, I move that the Senate take up a special orders calendar, special order second reading of bills consisting of House Bill 1116 that was heard in the Appropriations Committee meeting this morning. Mr. President, I move the Senate take up a special orders second reading bills calendar consisting of House Bill 1116 at the hour of 10:10 a.m. this morning.
The motion is that the Senate take up House Bill 1116 on special orders at 10:10 a.m. The motion requires a 2/3 vote. All those in favor say aye.
Aye.
All opposed, no. The ayes have it, and that motion is adopted, and the Senate will take up House Bill 1116 on special orders at the hour of 10:10 a.m. Special orders, second reading of bills. Senator Tate.
Thank you, Mr. President. I move that the Senate resolve itself in the Committee of the Whole for the consideration of special orders, second reading of bills.
Motion before the body is to resolve itself in the Committee of the Whole for consideration of the special orders, second reading of bills calendar. All those in favor say aye. All opposed say no. The aye has it. Thank you, Senator Kafalis. And motion is adopted, and the Senate will resolve itself in the Committee of the Whole for consideration of the special orders, second reading of bills. Senator Tate will take the chair.
The committee will come to order. Mr. Carpenter, will you please read House Bill 1116?
House Bill 1116 by Representative Rankin, Senator Moreno, concerning measures authorizing the Broadband Deployment Board to seek federal money earmarked for financing broadband deployment.
Senator Moreno.
Thank you, Mr. Chairman. I move House Bill 1116. There is no committee report. Colleagues, this bill simply allows the state of Colorado to apply for federal funding under the FCC Connect America Phase 2 auction. Ask for an aye vote.
Thank you, Senator. Is there any further discussion on House Bill 1116? There's an amendment on the desk. Mr. Carpenter, will you please read Amendment L001 to House Bill 1116?
Amendment L001 to House Bill 1116 by Senator Donovan, amend re-engross bill page 2, line 12, strike board, substitute board, except that the board shall not grant money to an entity whose
Senator
practice...
Donovan.
Thank you, Mr. Chair. Colleagues, I bring to you L001 and ask for your support on this amendment. It says that the board, upon receiving this money, will not grant out any of this money to companies that violate net neutrality protections as were established by the Open Internet Order. So I ask for your support on this amendment.
Senator, would you like to move the amendment as well? Apologize for the interruption.
No, thank you, Mr. Chair, and thanks for that direction. I do move L001.
Any just further discussion on L001? Senator Moreno.
Thank you, Mr. Chairman. Well, I certainly appreciate the amendment from my friend, the senator from Vail. I rise in opposition to the amendment. Normally, this is actually an amendment that I would be inclined to support. However, pursuant to custom, Joint Budget Committee members don't support amendments to Joint Budget Committee bills. as well as if this was to get on, this amendment were to get on, I think it would jeopardize the state's application for this federal funding. So with that, I ask for a no vote.
Thank you, Senator. Any further discussion on L001? Seeing none, the motion for the body is adoption of L001 to House Bill 1116. All those in favor, please say aye. Aye. All those opposed, say no. No. The noes have it. The amendment is lost. Is there any further discussion on House Bill 1116? Senator Donovan.
Thank you, Mr. Chair. Colleagues, I just want to briefly talk about this bill because primarily I want to set some expectations of how we discuss this bill with our constituents and about the issues of broadband in Colorado. So the fiscal note has a pretty substantial number associated with it as an estimation of what could be acquired by this bill. In my opinion, this is a very high number and not a realistic expectation of what this bill could bring back to the state for deployment for rural broadband infrastructure. So I think it's critically important that we set expectations in this building. And while I'm supportive of this bill, because I think an all of the above approach is the right approach for building out infrastructure in rural Colorado, I think we should be clear that what this bill could bring in. It is based upon, it is based upon what New York State did, and that's the model we're looking for. New York State, though, was applying for funding that was left on the table by the provider that did not accept that funding. And so it is not entirely clear that this waiver and this approach is actually applying for significant dollars because we don't know what was left on the table. So again, supportive of the bill, appreciate the JBC wading into this and looking for additional funding sources because that's an important part of the discussion of wiring rural Colorado. But colleagues, I just want to make sure that we understand that the fiscal note puts out a number of $250 million. That is the total amount for the entire country over 10 years. And we're not even sure if out of that total amount for the entire country over 10 years, if there will be even any available for Colorado to apply for. Thank you, colleagues.
Thank you, Senator. Senator Moreno.
Thank you, Mr. Chairman. Well, I don't disagree with my colleague from Vail. The Joint Budget Committee is particularly adept at emphasizing realistic expectations, especially when it comes to money. And the range for this amount of funds is anywhere between $100 million and the $250 million that the senator from Vail referenced. This isn't realistically a huge pool of funds, but every little bit helps to make sure that we can get that funding to those rural areas. And the other thing that's important to mention here, colleagues, and the Joint Budget Committee will be looking at addressing this issue separately through another piece of legislation, is the state match for these funds is really important. And right now, the state only has about $8.9 million to put up as a match for those federal funds. The reason New York was successful is because they did have a significant amount of state funding available to match for those federal funds. So that's something that we will have to address separately through another bill.
Thank you, Senator. Senator Crowder.
Thank you, Mr. Chair. According to the physical note that I'm reading, that's not quite accurate. The previous, not Senator here, but the previous indicated there was $250 million nationwide. According to this, it's $1.98 billion. And the state of Colorado alone actually would be in line for $250 million for this state alone. I just thought I'd read the physical note and make that correction, but nationwide is $1.9 billion. Thank you.
Thank you, Senator. Any further discussions on House Bill 1116? Senator Lundberg.
Thank you, Mr. Chair. I rise in support of the bill, but actually have some common ground with the good senator from Vail on realistic expectations. I also believe that we've heard other information on it. It could be a substantial amount, but I believe it's appropriate I know in my district, up in Estes Park, they're very concerned about broadband availability, which they don't have. But this isn't an automatic guarantee for that either. There are two sides to that coin, and that's what I rise to speak on, is the balance I see within this, in that the bill is simply allowing some additional resources to be found for this overall effort, but it isn't, in my opinion at least, specifying the exact path we're going to go down. And I also would add this one other element and caution to anyone who thinks that somehow the state of Colorado can guarantee broadband for everybody in the state of Colorado. I have been here too long to believe in that type of a scenario. I believe we should make good effort to find what we can, but my suspicion is that 5 to 10 years down the road, some technologies will be available on the private side that will probably eclipse our efforts. And yet I do support the bill. I think it's a prudent step to take at this point in time. Thank you.
Thank you, Senator. Any further discussion on House Bill 1116? Seeing none, the motion for the body is the adoption of House Bill 1116. All those in favor, please say aye. Aye. All those opposed, no. The ayes have it, and the bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee rise and report.
The motion before the body is to rise and report. All those in favor, please say aye. Aye. All those opposed, no. The ayes have it, and the committee will rise and report.
Senate will come back to order. Senator Tate.
Thank you, Mr. President. The committee has met and had a bill under consideration. Mr. Carpenter, will you please read the report?
Mr. President, your committee of the whole begs leave to report had on consideration the following task bills being the second reading thereof, makes the following recommendations thereon. House Bill 1116 passed on second read, order revised and placed on the calendar for third reading and final passage.
Senator Tate.
Thank you, Mr. President. I move the report.
Any discussion on the report? Are there any cows? I understand there is. Is there a cow? Huh? Seeing none, question before us is quickly. The motion before us is the adoption of the report of the Committee of the Whole. Are there any no votes? Seeing none, the committee with 34 ayes, no noes, 0 absent, 1 excused, the Committee of the Whole report is adopted. House Bill 1118 or 1116 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. Do we have an order? What else can we do? Announcements. Senator Scott.
Thank you, Mr. President. The Colorado Petroleum Council and the Colorado Petroleum Association would like to ask you to attend a reception this evening at the Brown Palace at 5 p.m. Please put it on your calendar. Thank you.
Senator Baumgartner.
Thank you, Mr. President. Members, today is the Colorado Legislative Sportsman's Caucus luncheon downstairs. Also, on your desk, you did find a Legislative Sportsman's Caucus membership form. If you'd like to be part of the membership or the Sportsman Caucus, please fill that out and get it back to myself or Jim Wilson or the senator from Pueblo. I won't make that mistake again. There is a change this year. Legislators and sportsmen will be served at 11:30 to noon. Staff will be served after noon. Thank you, Mr. President.
Senator Kafalis.
Thank you, Mr. President. Good morning, colleagues. I just want to draw your attention to a report that should be on your desk. It was placed on there this morning. It is entitled The State of Work in Colorado, the 2017 edition. I encourage you to take a look at it. It has some very good information, in my view, on employment, unemployment, wages, income issues, as well as poverty issues. Thank you.
Senator Lundberg.
Thank you, Mr. President. Members of the Transportation Committee, be aware that the Joint Budget Committee is meeting with the Joint Transportation Committee in room 271 upon adjournment. Please bring your what do we call this, staff budget briefing summary from the Joint Budget Committee to the meeting upon adjournment today. Thank you.
Senator Zenzinger.
Thank you. Colleagues, just want to remind you that CCI will be holding their legislative breakfast tomorrow morning at the old Supreme Court chambers, 7:30 to 9 a.m. So come get some coffee, carbs, and conversation with your county commissioners.
Senator Martinez-Umenick.
Thank you, Mr. President. Colleagues, I'd like to just let you know that we are starting a new legislative caucus on aging, and the first meeting is tomorrow. You're invited to learn what Coloradoans are saying regarding the challenges of aging and how vulnerable the aging population is in Colorado. It's tomorrow morning from 7:30 to 8:45 a.m. There will be a continental breakfast and coffee provided for that as well, and that will be across the street at 1525 Sherman in room 603. So perhaps if you'd like to go say hello to your commissioners and then come over to discuss our aging issues in Colorado, that would be greatly appreciated, as this is the inaugural meeting of this group.
Senator Crowder.
Thank you, Mr. Chair. Just an announcement that Colorado Hospital Association will have their annual legislative reception tonight at History Colorado from 5 to 7 p.m. And another quick announcement. I'm sure you're all aware that we had one of our senator's wife is under the knife in Colorado Springs today, Colonel Lambert. But I think we all need to keep her in our thoughts and prayers, and hopefully it's not a major deal. But I just thought I'd make sure everybody's aware of that. Thank you, Mr. Chair.
Senator Neville.
Colleagues, just wanted to remind you that Finance will be meeting on adjournment. We'll get rolling very quickly here, so once we're out of here. Also, just a reminder for those on Finance that we do have an 8:30 a.m. meeting tomorrow, Joint Finance, so don't forget, set your alarm clocks.
Senator Donovan.
Thank you, Mr. President. I just wanted to take a moment and read a tribute, but I also would like to thank leadership for working through the new process of tributes and resolutions, and for the speedy turnaround on this. It's certainly appreciated, so thank you. That being said, the second regular...
Members, we are doing a tribute. Please direct your attention to the will. Senator Donovan.
Thank you, Mr. President. We hereby extend heartiest congratulations and commendation to the Outdoor Retailer Show. In recognition of its contribution to Colorado's outdoor industry, we as members of the Colorado General Assembly welcome the Outdoor Retailer Trade Show to the state of Colorado. Outdoor retailers' support of Colorado's thriving outdoor industry and the many benefits that the outdoor industry affords this state will be appreciated by generations to come. Colorado's outdoor recreation industry generates $28 billion in consumer spending and $2 billion in state and local tax revenue. The state of Colorado is grateful for the outdoor retailers' exhibition of our world-class outdoor recreation opportunities and access to public lands. We extend our best wishes to all participants and attendees for a successful and enjoyable show. Colleagues, this is such an exciting opportunity that has come to our backyard. Over 50 countries will be visiting us. There are 11,000 registered purchasers descending on Colorado. And if you look through the exhibitors list, which is expansive, you will notice many familiar names that you recognize from being businesses from your own districts. So I'm thrilled that we have this show. I am thrilled that we stole it from Utah. It gives me a sense of high school rivalry pride that I haven't felt in quite some time. And we are thrilled to be the new center of the outdoor industry and a leader in this incredibly important aspect of the Western United States. So thank you, colleagues, for your time, and I hope you will join the Outdoor Retailer and Snow Show in some capacity over the upcoming days and weekend. Thank you, sir.
Thank you, Senator Donovan. Any other announcements? Mr. Majority Leader.
Thank you, Mr. President. I move the Senate stand in recess until 1:30 p.m. today.
Question before us is to stand in recess until 1:30 today. All those in favor signify by saying aye. All those opposed say no. The ayes have it. We will stand in recess until 1:30.